Hi, well, first I'd like to start off by thanking Vigorate and everybody at Vigorate for putting together this event and for having me here today. They've done a very good job. There's a very good turnout here, and looking forward to talking about CASL, even if we have been talking about this for a very long time. Just to start off by saying that I think this is obvious, but I have to point out that this isn't legal advice. Everything I say here is entirely my views based on what we know about the legislation and sort of factual understanding of how we think the law is going to be interpreted and applied, but we can only really say so much on certain issues because at the end of the day it's ultimately up to the regulators and the courts to decide how the law is to be interpreted and applied. What we want to cover today, CASL is a very complicated piece of legislation. There's a lot going on there. So we really want to focus on what we think matters most at this point in time and really what we can get through in the next 20 or 25 minutes. I'm going to talk briefly about what it is. I think most people here probably have a pretty good working background of what CASL is, but just to make sure that we're all sort of working from the same point of reference, I'm just going to bring everybody up to speed on what CASL is. Where it's at, it's been a very long process. Getting to this point, I want to talk a little bit about who enforces the legislation, some of the key issues that I think are important for senders and reflect a lot of the questions that I am seeing these days. Talk a little bit about getting prepared, and with that in mind, this whole slide deck has really been set up with a certain methodology or approach in mind that organizations can take when they're getting prepared for CASL and the various steps that you can walk through in doing so. We're going to focus on the electronic messaging rules, recognizing that CASL does a lot of things. And I should also mention that the slides really coincide with the campaign and database checklist that we've put together and that Vigorate will be able to provide to you. Just very briefly, what is CASL? Again, it does a lot of different things. It creates rules for the installation of computer programs. We're not really going to get into that today. It creates a general prohibition against unauthorized alteration of transmission data, something else we're not really going to cover today and probably not that relevant for most everybody here. That's really getting at some of the more nefarious types of activities that we see on the internet, like phishing and farming. So what we really are going to focus on are the anti-spam rules, and these are the rules that apply to the sending of commercial electronic messages, or CEMs. As I already mentioned, it's been a very long process getting to this point where we finally know when CASL is coming into force. The law was actually passed by Parliament back at the end of 2010, so just over 3 years ago now. The biggest pieces of the puzzle, or what we've really been waiting on, have been final implementing regulations. Both Industry Canada, which is the government department responsible for the legislation, and the CRTC, which is the enforcement agency under CASL, are both required to pass implementing regulations. And these regs really do a few important things. The CRTC regs add further detail around certain requirements under the legislation. For example, CASL says that every time we ask for consent or send out a CEM, we have to provide certain prescribed information. Well, the CRTC regs prescribe exactly in detail what that information is supposed to be. The CRTC regs were finalized in March of 2012. The Industry Canada regs took a little bit longer, and that's, well, for a few reasons, because the Industry Canada regs deal with, I guess, some more substantive or some more weighty issues, and they were seen as an opportunity by a lot of stakeholders to try and get further exclusions for certain types of activities or CEMs. And that's really the bulk of what we see in the Industry Canada regs are a number of exclusions and exceptions for certain forms of commercial electronic messages, which we'll talk about a little bit. When Industry Canada published its final regs in December, so just over a month ago now, Industry Canada also announced coming into force date. And as most of you are likely aware, CASL comes into force on July 1st of this year, or most of CASL comes into force at that point in time. They've decided to delay the rules that apply to the installation of computer programs until January of next year. And they've also decided to delay the private right of action for a period of 3 years. And I'll talk a little bit more about what the private right of action is, but in a nutshell, it allows any person who claims to be affected by a violation of CASL to file a lawsuit. And the reason they decided to delay that is because that's quite a scary proposition for a lot of senders, a lot of businesses. It really creates a lot of risk. It's really difficult to know how the private right of action might be used by litigants. And while we may be able to predict with a certain degree of certainty about how the CRTC is going to enforce the Act, that is much less certain. So I think that was a very wise thing to do. Give the CRTC and possibly the courts a few years to establish some precedents and guidelines under the legislation before they let the plaintiff side lawyers sort of loose on this. At a very high level, there are really 3 primary requirements under CASL with respect to sending CEMs. First and foremost, and really what we end up talking about the most, is the requirement for consent. With the exception of certain exclusions under the legislation, anytime we send a CEM, we have to have some form of consent before we can send. And CASL says that consent can either be express or implied. There are certain identification requirements. Every time we send a CEM, we have to say who we are and include certain contact information in the message. And finally, which is no surprise to anybody here, is the requirement to have an unsubscribe mechanism. So every CEM must include a functioning unsubscribe mechanism that allows an individual to unsubscribe readily and at no cost. This slide sort of describes one approach or one process for going through and conducting a review for the purposes of CASL compliance. Again, this isn't the only methodology. It's just one that I've come up with and one that clients seem to like because it approaches it from the perspective of looking at exclusions first. And then if we can't rely on exclusions or implied consent, well, then we go to express consent. And this is sort of a methodology that's emerged out of dealing with the transition into CASL compliance. And a lot of it stems from the fact that if we can't rely on an exclusion or implied consent, then we have to actually reconfirm subscribers. So trying to provide us with the longest period possible before we have to reconfirm, assuming that reconfirmation is necessary. So again, this is really just one sort of general approach for walking through the process of CASL compliance. So the first step really speaks to application. When we're trying to figure out how CASL applies, the first question really is, does CASL apply? And CASL applies to commercial electronic messages, and there are really 2 components to the definition of a CEM. First, it has to be commercial, and the Act is drafted very, very broadly in this respect. It says that a message is commercial if it's reasonable to conclude that it has as one of its purposes to encourage participation in commercial activity. So that's important because it doesn't say the primary purpose or the main objective, it says one of the purposes is to encourage participation in commercial activity. And this is a fairly significant departure from what we see, for example, in the U.S. under the CAN-SPAM Act, which has the concept of a primary purpose. For example, if the primary purpose is merely transactional or relational in nature, senders there can slip in sometimes a little bit of commercial content, and it won't render it to be a commercial electronic message, but the threshold is much, much lower under CASL. Second, the message has to be electronic, and again, the definition is very broad in this respect. It specifically refers to things like email and instant message or a telephone or other account. So it applies to any electronic message sent to an electronic address that's attached to an electronic account. That's really the key defining feature. And they've tried to draft this to be as technologically neutral as possible, so that it applies to the primary forms of electronic messaging that we currently see right now, as well as other forms of electronic messaging that might emerge in the future. Because of how a CEM is currently defined, it would apply to voice and fax messages, but there's an explicit exclusion for voice and fax because they're currently addressed under the unsolicited telecommunications rules. So just to be clear, CASL, as of right now, does not apply to live or recorded voice messages or fax messages. From a jurisdictional perspective, CASL itself says that it applies to any CEM sent to or from a computer system located in Canada. So if we're sending to Canadians or if we're sending from Canada to foreign individuals. However, Industry Canada added an exception in its regulations, which were published in December, that says that CASL does not apply to a CEM that's sent to a foreign jurisdiction that has its own anti-spam regulations, so long as the message applies to those regulations, or sorry, complies with those regulations, and there is a reasonable expectation that it's actually going to be accessed in that foreign jurisdiction. So these are really messages that are targeted outside of Canada, not targeted at Canadians. We can't be sort of inadvertently or targeting it to Canadians and then turn around and claim that, well, we thought it was only going to be accessed in a foreign jurisdiction, because I think that will be a factor that will play into whether it's reasonable to expect that it's only going to be accessed in another country. So the second step in this process is to look at the exclusions. And there are now a number of exclusions in the legislation, both between CASL itself and the exclusions that were introduced by Industry Canada in its regulations. And I'm not going to go through them all in detail because there are a lot of them. And these are things that you can look up, and they're all listed in the campaign checklist that you'll have access to. I'll just highlight a few that I think are particularly relevant. One is any CEM sent between two individuals that have a personal or family relationship, and those are defined concepts. They're defined in the Industry Canada regs. This is potentially relevant to things like refer a friend type promotions. Any message that's sent to inquire about a product or a service is exempt. And on the flip side, anything that's sent in response to an inquiry or a request, or that is otherwise solicited by an individual, is also completely excluded. So if somebody sends you a message asking about one of your products or services, your response is completely excluded from the legislation, from all of the requirements. There's another sort of special category of exclusion that I've set out separately, and that's the referral exclusion. Again, this is in the Industry Canada regulations. And this was really put in there to ensure that professionals and salespeople can continue to rely on referrals through trusted third parties as a means of prospecting and building their business. Particularly relevant for people like me, lawyers, who may reach out to a potential client as a result of a referral. And what this particular regulation says is that a sender can send a single commercial electronic message based on a referral so long as the person who makes the referral has a personal, family, or existing business relationship with both the sender and the recipient. The sender can then send one single CEM, and when they send that message, they have to identify the person who made the referral and then use that as the beginning of a relationship, forming a relationship with the recipient to then follow up and establish some form of consent or potentially rely on one of the exclusions under the legislation. Again, this may be potentially relevant for forward to a friend type promotions. And then there is another list of exclusions, and I say exclusions from consent because this section of CASL is actually a little bit confusing because of how it's drafted. What this particular subsection says is that consent is not required for a commercial electronic message that solely provides a quote or estimate, facilitates an already agreed to transaction, provides warranty, safety, recall information, etc. So these are really transactional type messages. This section was added to CASL during the committee review process in response to concerns from stakeholders who were saying that the legislation was going to basically prohibit them from sending these types of messages without consent. The most reasonable response is that anything that merely facilitates a transaction or provides warranty, safety information, etc., is not a commercial electronic message according to the definition. However, the government included this section in response to these concerns and to address those concerns that were raised by stakeholders. So it creates a little bit of confusion because some have read this section to imply that any of these messages are commercial electronic messages merely due to the fact of how this subsection is actually drafted. My view is that it's the actual definition of a CEM that matters, and that it can't merely be a CEM by virtue of the fact that it's listed in this subsection. There are definitely differing views on this. I've heard about differing perspectives from the CRTC. So again, there's a little bit of confusion about exactly how this subsection is meant to apply, but I think the most reasonable approach is to really rely on the definition of a CEM. If it's a CEM and it also provides warranty information or information about the ongoing use or purchase of a subscription, then CASL applies, and the identification and unsubscribe requirements would apply. You're just able to send it without consent. However, if it's something that merely facilitates a transaction or merely provides warranty, recall, or safety information and really doesn't contain any commercial content or doesn't encourage somebody to participate in further commercial activity, then in my view, that's not a commercial electronic message. But again, that's just my view, and the CRTC could differ from that view. Then if we can't rely on any of the exclusions, we move on to implied consent. And CASL effectively, they call it implied consent, but really it's more like deemed consent because CASL effectively deems consent to exist in any of the following four categories. First of which is the existing business relationship. And there are several subcategories of the existing business relationship. I won't go into them all. But this is really most relevant in a business-to-consumer context. An existing business relationship arises, for example, if someone has made a purchase within the past 2 years, or if they've been in a written agreement with you within the past 2 years. So this actually provides quite broad latitude to follow up and send CEMs to current and potentially former customers. There's an existing non-business relationship. This is going to be less relevant for businesses. It really applies only in the voluntary and in charitable context. For example, if someone has donated or volunteered for a charitable organization or a political party, then that's where the existing non-business relationship arises. And then the last two categories are more relevant in a business-to-business context. The first is conspicuous publication. So someone has conspicuously published their electronic address, for example, on a website or in a directory. And number 4 refers to where the recipient has actually provided their electronic address directly to the sender. And both of 3 and 4 have a couple of important conditions attached. First of all, the recipient cannot have stated that they do not want to receive unsolicited commercial electronic messages. And the second condition is that anyone sending based on 3 or 4 can only send a CEM that's related to the recipient's business, official, or professional capacity. So that's why it's really more relevant in a business-to-business context as opposed to a business-to-consumer. So the next step is we can't rely on any of the exclusions. We don't have implied consent, so that means we actually have to ask for express consent. And these are the general requirements that arise when we're asking for express consent. We have to clearly and simply describe why we're asking for consent. For example, you're signing up for our newsletter, you're going to receive offers and promotions. We may provide offers and promotions on behalf of our third parties or our affiliates. Those types of things. It has to be explicitly brought to the attention of the individual. So it can't be put in a privacy policy or terms of use. It has to be right up front. The person who's asking for consent has to identify themselves, so they have to say who they are. Generally not an issue for most brands. That's usually spelled out quite clearly and obviously. Really, these identification requirements were put in there to address concerns having to do with more spammers and certain types of mailing that we see where it may be less clear who's actually asking for consent and who's going to be sending the messages, where it might be confusing to consumers. And again, the law says that we have to provide certain prescribed identifying and contact information. This is spelled out in further detail in the CRTC regs. The individual has to be told that they can unsubscribe, for example, by clicking on an unsubscribe link in an email. And finally, we have to be sure that the process for asking for consent actually qualifies as express consent. And this has been a sort of long and ongoing issue about exactly what express consent means for the purposes of CASL. Under privacy legislation that's been in place for over a decade, express consent can look like different things. We may be able to use a pre-check box. In some cases, if we're dealing with more sensitive information, maybe we can't use a pre-check box. Well, the CRTC has come out and said very clearly that in its view, pre-checked boxes are not acceptable. In its view, that does not qualify as express consent. So this is a pretty important change from what we're used to seeing under privacy legislation, even though many senders may have already made the move to boxes that are not pre-checked. They still are quite widely used. And finally, CASL says that any person claiming to have consent bears the burden of proving it. So that means we need to retain some form of evidence. And again, there are no specific requirements as to exactly what this evidence should be. I think the guiding principle is that you should feel comfortable that if someone claims that they never provided you with express consent, that you should be able to prove to a regulator in the context of an enforcement action that they actually did provide consent. So these types of things, the types of things that we typically see is a database that would collect a time and date stamp, the source, so it was collected on a web form, on this website, possibly an IP address of who provided the consent, if possible. And I also think if you really want to be prepared, I think it's a good idea to keep a screenshot of a web form, or if you're using a paper ballot, an image of that paper ballot, because sometimes these things get lost over time, or we change websites, and if it was an enforcement action 2 years down the road and we don't have that website anymore, we could at least pull it in an image and show the CRTC, well, this is what the form looked like at the time, and it was CASL compliant. So we're able to demonstrate that we actually did get express consent. And finally, when we actually send a CEM, there are certain requirements. Again, we have to provide the identity of the person sending the message. If the message is being sent on behalf of another person, for example, in the context of a list rental or a newsletter type communication, then we have to say who is sending and on whose behalf the message is being sent. We have to include the prescribed identifying contact information. Again, this is spelled out in the checklist. We have to have an unsubscribe mechanism, and we have to avoid false or misleading representations in a message, subject line, or sender information. And this is actually spelled out in the Competition Act, which deals with false and misleading representations. Again, not likely to be a huge issue for a lot of senders, but it's definitely something to be aware of, that you know, from a substantive perspective, the communications that we're sending out couldn't be considered false or misleading to the recipients. Moving on to enforcement, there are really two components to enforcement under CASL. There's a public component, what I refer to as public, and a private component. So first we have the Canadian Radio, Television, and Telecommunications Commission, or the CRTC, which is the enforcement agency under CASL. The CRTC has been around for a very long time. Its role has been in the regulation of the telecommunications and broadcasting sectors, not really a typical enforcement type role per se, but it really became an enforcement agency when the unsolicited telecommunications rules came into effect in 2008. So it does have a few years of experience as an enforcement agency. CASL provides the CRTC with quite broad investigatory powers to go in and compel evidence where necessary. But most importantly, the CRTC has the ability to impose administrative monetary penalties, or AMPs, of up to $10 million per violation, which is potentially huge when you think that that could be a separate $10 million fine for every single email that's sent. Legislators say that they included these really significant penalties in order to act as a substantive deterrent to spammers. The argument has always been, if we don't have the ability to impose such significant penalties, and the spammer only faces a prospect of a fine of a few $100,000, well, they'll just look at that as a cost of doing business, and it won't be enough of a deterrent to actually stop spammers. I think it's unlikely to see a fine of several million dollars against a brand, or what we commonly refer to as a legitimate business who's really just trying to do the right thing, who's made a mistake. I really don't expect that. That's not the objective of the legislation, and I don't think these types of organizations are going to be on the CRTC's radar, particularly at the outset. But that being said, if you're intentionally or knowingly or flagrantly violating the rules, the CRTC will not be afraid to hit you with a penalty. Just recently, the CRTC announced that it had issued an AMP of $200,000 against a company that owns and operates 5 Weedman franchises. So that's a very significant penalty against a company of that size, and that was issued under the unsolicited telecommunications rules. And based on what they announced in their press release, and according to the notice of violation, this company was clearly in violation of the rules. So the CRTC was not afraid to hit them with a very significant penalty. So I would expect a similar approach under CASL. It's important to mention that CASL has a due diligence defense, so if you can demonstrate that you exercise due diligence to prevent a violation of CASL, then you can't be found liable. And so that really means being able to demonstrate that you've undertaken efforts to ensure that you're in compliance with CASL. You've set up policies and procedures. The marketing department knows what they can and can't do. Your agreements with service providers or clients are very clear on what those partners can and cannot do, et cetera. Those types of things are going to be important, I think, in terms of demonstrating due diligence. And then the second half on the private side, and I've already briefly referred to this, is the private right of action that would allow any person affected by a violation of CASL to file a lawsuit in a superior or federal court. The private right of action would allow a court to award actual and/or statutory damages, recognizing how difficult it is to quantify harm from things like spam. And we see this in the privacy space generally, that it can be very, very difficult to quantify harm. The legislators decided to include the ability for a court to award statutory damages, which essentially damages that can be awarded without proof of harm. With respect to CEMs, a court can award a damage of up to $200 per violation. So that's not nothing near the $10 million that the CRTC can impose. And so it's not likely going to be lucrative, or it's not going to make sense for an individual to sue a company on their own if they've received a few messages that they don't want. However, this would be available, for example, for class actions. So if there are thousands of individuals who have received the same email several times from a sender, then all of a sudden it could be a situation where a plaintiff's lawyer decides that it makes sense to file a class action lawsuit. But again, the private right of action does not come into force until July 1st of 2017. So it gives a little bit of time to sort of get things going and not have to worry about the prospect of a class action lawsuit. So just a few things that I want to briefly touch on before we finish off. And again, these are some of the more recent developments and some of the issues and questions that I'm seeing most commonly these days. It's important to point out the transitional provision. And this, I hope, I've done the best I can. I've tried to explain the transitional provision and how it applies in the database checklist that you'll have access to. And really what this provision does is it extends the existing business relationship for implied consent. And what it effectively says is that if you've ever had an existing business relationship with an individual before CASL comes into force, and that relationship involves sending commercial electronic messages, so they've been on your list and they've been receiving things from you, then that existing business relationship is deemed to exist on the day that CASL comes into force, and it's effectively extended for 3 years. So we now know that that would take us to July 1st of 2017. So it means that if somebody has ever really made a purchase from you, or they've ever inquired about one of your products or services, the transitional provision says that you have an existing business relationship that lasts until July 1st, 2017. So that's potentially a significant tool that will assist a lot of senders in transitioning over into CASL compliance and provides you with quite a lengthy window of opportunity to actually get express consent and reconfirm that subscriber if you decide to do so. Also, more recently, both Industry Canada and the CRTC have said that they would consider any express consent that was obtained already in compliance with our federal privacy legislation, which I refer to as PIPEDA. If it's compliant with PIPEDA, then it will be considered compliant with CASL going forward. Again, that's for express consent obtained before CASL comes into force. And this is also important because for many years, a lot of senders have been looking at PIPEDA because that's been the regime that regulates the sending of commercial electronic messages in the private sector. And really a couple of differences between express consent under PIPEDA and CASL. First, and obviously PIPEDA doesn't spell out all those specific requirements in terms of the information that we have to provide when asking for consent. For example, we may not have provided a mailing address or a telephone number, for example. So that's one difference. The other is that, as I briefly mentioned, express consent is not defined so rigidly under PIPEDA, and it's generally okay to use a form of opt-out express consent, and what I mean by that is that pre-check boxes have been okay for collecting and using personal information for marketing purposes under PIPEDA. But again, it's context specific, so if we're collecting generally non-sensitive personal information, for example, if we're asking for consent to add somebody to a list for an electronic retailer to hear about deals and promotions from that retailer, that's generally not going to be sensitive. If we're asking for more sensitive type of personal information, for example, related to a medical condition or somebody's financial information, that might be more sensitive, and we probably shouldn't use a pre-check box. So again, that's a fairly significant step up in terms of what is required under CASL. But this sort of grandfathering notion refers to the idea that if we've got express consent already considered compliant with PIPEDA, it's going to be also compliant with CASL going forward, and we actually wouldn't have to reconfirm those subscribers. And finally, we talked about this already a little bit, but what exactly is a CEM? There's a lot of confusion out there around really the threshold around when a message becomes commercial. And again, the threshold is quite low. CEM is defined very broadly in the legislation. Based on everything that I've seen and heard from the CRTC, they've taken quite a broad approach to interpreting and applying this definition. And really the key takeaway is if you think it might be a commercial electronic message, it probably is. And even if you think it might not be a commercial electronic message, it still might be a CEM. Again, it's based on the content of the message. It's based on links in the message. And if it has one of its purposes to encourage participation in a commercial electronic activity, then the message would be considered a CEM. And finally, reconfirmation. At the end of the day, there are going to be certain subscribers who likely need to be reconfirmed, and really this means that we would have to reach out to them and obtain express consent before CASL comes into force, or in some cases, if we're able to rely on implied consent in the transitional provision, we may be able to extend that out quite a bit further. But again, I hope that the database checklist will be quite helpful in terms of figuring out who and when needs to be reconfirmed for the purposes of CASL. So that's everything I have to say for this presentation. I hope it's been helpful. And again, I'd like to thank Vigorate for having me and for putting this event together. This slide just provides a list of further resources that you can use for further information. And I encourage you to follow me on Twitter if you want to know more about e-marketing law in Canada, and to reach out to us if you have questions. So thank you very much.